Call the first case, State of Florida versus VIDAL, Santiago.
May it please the Court, my name is Chris Davenport and I represent the State of Florida. I'd like to reserve 2 minutes for rebuttal. This is an appeal of an order granting the defendant's motion to dismiss a second-degree murder charge on the basis of double jeopardy after the defendant moved for a mistrial during the testimony of the State's first witness. This charge stemmed from a fight in a jail at the Brevard Correctional Institution. The first witness was a fellow inmate. He testified that he saw the defendant pull a shank out of his sock while they were in the dining room, and then they lined up to go back to their cells. He saw the fight started. He saw the defendant interacting with the victim. The defendant had his hand on the victim's shoulder. He heard what sounded like a striking sound. The victim bent over to the side, clutching his side, and the defendant took off running. The witness testified that he grabbed a shovel and took off after the defendant. The prosecutor asked him why he did that, and then we started to get into problem areas. The prosecutor asked, "What did you believe you had just seen?" The defense counsel objected to that. The objection was sustained. Then the prosecutor asked, "Why were you chasing the defendant?" The court instructed him not to speculate, and the witness answered, "He stabbed the victim." At that point, the defense counsel stood up, moved for a mistrial, said he was speculating. The prosecutor tried to fix that and said, "What caused you to believe that the defendant stabbed the victim?" Another speculation objection was raised.
You haven't cross-appealed you haven't appealed the propriety of the underlying evidentiary ruling that brought that problem up to begin with.
Right.
But essentially, as I understood it, the problem was the witnesses said, what did you see, or what did you think you saw? I think I saw my friend get stabbed.
Right.
And that provokes all of this. What's wrong with that? If that then explains his then existing mental condition or subsequent conduct.
Exactly, and the prosecutor did argue that below, that was certainly admissible for him to say, to explain why he was chasing after this guy with a shovel.
It doesn't necessarily mean it's true, it just explains his conduct.
Exactly.
But you haven't appealed that.
Right, because I don't think we can legitimately take the position that the prosecutor had the right to ignore the trial judge's ruling.
Well, that was a different issue, wasn't it? In other words, the motion in limine went to the hearsay statement.
Right.
But when Durant was on the stand, he wasn't asking him what you said. He wasn't asking for the hearsay statement. So the motion in limine didn't apply to Durant's testimony.
Right. The motion in limine had nothing to do with that. That was a hearsay testimony to the officer. An officer was going to testify that this same witness, that's why it gets confusing, it's the same witness, had told the officer that that the defendant stabbed the victim. The problems arose at the trial based on this speculation objection, and the trial judge kept sustaining that. They were struggling with that, probably because the ruling was incorrect. I mean, how you work around a ruling that says the witness can't testify about something that's proper. But he certainly was obligated to follow the trial judge's ruling, and we're not arguing that the trial judge
now,
could be...
my reading of the record was that the objection was that they were asking for a comment on the ultimate issue.
Right.
And the trial judge never sustained an objection, did he? He just simply coached or told the witness not to speculate. Isn't that correct?
Right. It seemed like there was some confusion at trial. The prosecutor was trying to get him to explain why he was chasing him with a shovel. Defense counsel was concerned that the witness was going to testify he saw something he didn't see and make an opinion on an ultimate issue, which is not like the prosecutor asked him, did you think the defendant is guilty? I think that would be opinion on an ultimate issue. But he never asked that. That's how the objection started. Then they got into this speculation problem, which was the trial court's main concern. He didn't want the witness to speculate as to what he saw. He wanted him to testify exactly what he saw. So they took the jury out. They went through this proffer, what questions were okay and which weren't. The prosecutor kept saying, I can ask him what he observed, and obviously he could. The trial judge was fine with that. When they got into, what did you believe had happened, that's when the objections started again. Had some confusing rulings. Ultimately, they brought the jury back in. The prosecutor was able to ask, what did you see or hear that caused you to chase the defendant? And that was the final question that finally got through. No more objections were raised. Well, the defense counsel objected. Trial court said, clear that up on cross, and he did. On cross-examination, they asked him, did you actually see him stab him?
But
He said, no.
wasn't the real problem in this case when the correctional officer testified and testified to a statement that had been specifically dealt with in an earlier motion in limine?
That's something that defense counsel brought up as a problem. Now, when the trial judge made it to
You would agree that it was a problem, wouldn't you?
I agree that that was inadmissible testimony. The question, though, isn't whether or not a mistrial should have been granted. This is a pretty narrow issue, whether or not the prosecutor intentionally goaded a mistrial. So it is a significantly different standard.
But would you agree with me that when the prosecutors believed that simply because an earlier trial judge had made the ruling that it somehow was not binding was erroneous?
I would agree that that was not his best argument, yes, Your Honor.
And would you also agree with me that it would be kind to say that he was negligent in not informing his witness? Don't say X, whatever the X was.
Well, I think that's a closer issue. Certainly, in an abundance of caution, he probably should have told all of his witnesses. He explained that he told the lay witnesses not to do that. They were inmates. They were kind of wild cards. So he instructed them. This was a law enforcement officer who was at the hearing on the motion in limine. He knew it was an issue. Certainly supported by the record that he was there for the ruling that said, let's not bring this up until we have a proper and figure out if it's an admissible hearsay. But when you look at the question that generated that problem, the prosecutor asked this correctional officer, what did you see when you came out of your office? When he testified at the motion in limine hearing, he testified, I saw, people were running, I saw this particular witness was chasing the defendant with a shovel, and I went after him. That was the answer he gave then. The hearsay came in after they had corralled this witness, had him on the ground. Another officer came over and said, why were you doing this with the shovel? And the guy said, I saw the defendant stab the victim. That's when the hearsay problem started. He had him on the ground. So when the prosecutor said, what did you see when you came out of your office? It was certainly not an expected response for the witness to say, I saw him chasing him with the shovel, yelling, he stabbed the other man.
You don't think as a matter of general practice that the prosecutor or any attorney, the same on the defense side, had they been in that position, had an obligation to instruct witnesses on rulings of the court that were specific to their testimony?
I think if he had asked him what happened after you had the inmate on the ground and opened the door to that kind of an answer, I don't think that would have been an improper question. To say, what did you see when you came out of your office? It was completely unexpected for this guy to change his testimony and say, I saw him yell in this hearsay statement. Let me also note that the trial judge, when he ultimately granted the mistrial, which happened after 8 days of testimony, 7 hours of deliberation, they had a readback of this first witness. The trial judge said, I probably should have handled this differently. I'm going to grant a mistrial. There was a lot of argument about that, and one of the things the trial judge specifically said is, I'm not granting it based on this motion in limine problem. I'm granting it because of this first witness who speculated, in the trial judge's opinion, completely improperly, and that's why he granted the mistrial. It had nothing to do with the motion in limine. Even, considering the motion in limine, though, that was not an intentionally elicited statement. There's a lot of cases that say if a witness's response isn't intentionally elicited, it's not evidence of goading. And keeping in mind that the standard here is whether the prosecutor intentionally goaded the defendant into requesting a mistrial, that standard clearly isn't met here, and the trial court's order should be reversed. And I guess I'll save the remainder of my time. Thank you.
Thank you.
Good morning. May it please the court. My name is Bryn Newton, and I represent VIDAL, Santiago. The state said that the motion for the mistrial, or the granting of the mistrial, had nothing to do with the motion in limine. But Judge Holcomb, who heard the motion in limine, specifically excluded the hearsay remarks because he had listened to Eric Durant testify at the motion hearing and found his opinion, or what he said was too unreliable. what he said later would be too unreliable as hearsay, and it was based on the fact that Eric Durant didn't see him stab his homeboy. And so he wanted no mention of that, certainly in opening statement, and then I'll decide later when you make a proffer. This is Judge Holcomb, pretrial, saying, then I'll decide whether any of this is admissible. So rather than...
Was the motion in limine directed to the statement? I thought the motion in limine was directed to the hearsay statement made by Durant to the correctional officer when he's, basically, why are you chasing this guy with a shovel? He stabbed my homeboy.
Well, and in the hearing, fleshed that out, and one of the reasons it would be excluded was because he didn't see him do it. He saw something which was very consistent with the stabbing. And again, the judge said, just don't mention any of this in the opening, and then we'll deal with each of these matters in the trial. And so whether it was admissible or not, as what Eric Durant's opinion was, and I think belief is awfully close to the same as an opinion. What do you believe you saw? What do you believe happened?
At the time that Eric Durant was on the stand, the only objection was that this opinion goes to the ultimate fact. They didn't. The defense lawyer trying the case didn't even raise the issue that it might be in violation of the motion in limine. Isn't that correct? When you're arguing it's in violation of a motion in limine that goes to a hearsay statement, and when Eric Durant's on the stand, it's not a hearsay statement. It doesn't appear to me to be a violation of the motion in limine to ask the question and try to elicit that response. And the defense lawyer didn't even make an objection saying that it was a violation of the motion in limine, did he?
Well, I guess he didn't use the magic words any more than Durant used the magic words. My opinion is he was committing second-degree murder. But he was objecting to Durant testifying basically to what he thought he saw, what he believes was happening when he saw what little he did see. So I guess the defense lawyer did not use the magic words. This is violating Judge Holcomb's motion in limine, but it was speculating, and it was because it was nothing better than speculation that Judge Holcomb thought there's a problem with using even what we could be called an excited utterance later, because he didn't see it. He reached this conclusion. So it was the same objection without the magic words, I guess, at the time.
So in your estimation, for example, if I see a robber walk up to an individual with a firearm, put the gun up and say, your money or your life, and that scares me to the point that I avert my eyes, and a second or two later I hear a gunshot, right in front of me I hear a thud, someone falling on the floor, and I open my eyes and I see the victim laying on the floor bleeding and the robber running away. You think it would be inadmissible for me to say, why did you call 911? Well, I thought I had just seen a shooting.
Well,
I had, the scenario I just created, I did not actually see the shooting. But a logical inference from the evidence that I did see was that there was a shooting. So you think that it's inadmissible for a layperson to give that testimony to explain, for example, why did you call 911?
Well, I can't remember the crime and the case that I cited in the brief about the taxi driver giving his opinion of what the crime was. There's just certain, certainly what you testified to. Why did you call 911? Because of what I just saw would be an appropriate answer, not because, in my opinion, there was a first-degree felony.
No, I agree they can't. That's a legal conclusion. But would it be improper, for example, for them to say, I called 911 because I believed I just saw a shooting?
Isn't that the kind of lay opinion that 90.701 says is admissible? Simply because that's, in many instances, the best way to describe what you think you saw, and then in cross-examination or even on direct, it certainly can come out that, well, you didn't actually see this, maybe there was a problem in your perception here, maybe you didn't see what you thought you saw. But it seems like when you're talking about eyewitness testimony and the witness's opinion or inference as to what he or she saw, that's exactly what is admissible under 9701.
Well, the problem was Judge Holcomb found that he
No,
didn't,
Judge Holcomb,
didn't say he couldn't testify to what he saw.
right.
But it was his utterance about his characterization of what he saw, which was going to be kept out, which should include what his own conclusion was. Him personally saying, well, I think I saw a stabbing.
Isn't that the purpose, though, cross-examination? And in this case, wasn't the defense granted a full opportunity to cross-examine as to that issue?
They brought out that he didn't actually see what happened. And again, though, this is the point at which Judge Stein, the successor judge, granted the mistrial, had to do with Durant's testimony. But
The firefighters, be seated, please. The firefighters assured us, Ms. Newton, that it had nothing to do with your argument.
for my next trick,
Well, we appreciate your patience, and apparently the explanation from what they tell us is because of the brush fire that was out by Halifax Hospital last night, which I guess is still smoldering somewhat. I guess the air handlers pulled enough smoke in to set off the fire alarms, which are, I guess, somewhat sensitive. So, are you ready?
yes, sir.
Whenever you're ready, please resume.
And we'll assume the testimony of Mr. Durant's opinion would be admissible. If just assuming that, there was nevertheless, if not an adverse ruling specifically about his testimony, there was obviously a question about it. Judge Holcomb based his ruling, even if he didn't specifically limit it to the corrections officers. He says it's because he didn't see enough to have this opinion or to have.
Let me ask you this: if you're conceding that it's at least debatable as to whether the testimony from Durant was admissible, then how do you leap from there to the conclusion that the prosecutor was goading a mistrial by asking a question that arguably was designed to lead to perfectly admissible evidence?
Well, he may have had admissible evidence, but he had an adverse ruling, and he was
Not as to Durant's testimony, he didn't.
Well, the Judge Holcomb addressed that. He did, and again, didn't say the specific words, but the thing is, may have been the first thing that happened, and it was the last straw, but it was all through the trial. There were objections, motions for mistrial, and motions to dismiss because of the pattern, the state attorney's pattern of conducting the trial. And in the motion to dismiss, those were recounted at length. And then at the hearing on the motion to dismiss, Judge Stein granted the motion based on the overall conduct of the trial.
Is that what Judge Stein said? I thought that he said it was based not on a violation of the motion in limine, but solely on Durant's testimony.
Yes, sir. He eventually, yes, he found later, he found it was gross negligence and that sort of thing. But the motion, all right, well, so let's assume he denied the motion. That's I'd be more familiar with that territory. The judge denied the motion, but you can look at the record and see the conduct of this trial, which at best calls for some kind of intervention from the Center for Professionalism, the way these prosecutors handled this trial before and after and during the trial. And the third DCA in Duncan did that fact-finding. They overruled Judge Kogan and drew the inference which Oregon v. Kennedy allows you to draw from the overall circumstantial evidence of the prosecutor's conduct. And this, in Duncan, it was a toy gun that a second trial and a different judge would allow the prosecutors to get into evidence. In this case, it's a shank that now when they get to retry it, they're not going to have Judge Stein's bothersome discovery violation ruling. They're going to get shank into evidence. And they're going to have an advantage. They'll, it was speculative, but maybe they'll get some of these inmates to figure out that as long as they don't cooperate, they're going to be sitting in the county jail losing their game time. Maybe they'll be a little better witnesses at the second go-round. But the shank will help, and maybe Judge Holcomb would revisit his ruling, which they didn't allow Judge Stein, give him the opportunity to do. So there's the discovery violation that's going to be cured by a retrial.
Well, I don't disagree with the premise that the prosecutor should have instructed the correctional officer, make sure you don't make the hearsay statement. And apparently he didn't do that. But wasn't that error the sole basis for the motion to dismiss, the order dismissing it? When he dismissed the case because of prosecutorial misconduct, wasn't that the misconduct that he focused on?
Well, they certainly recounted all of it, and I apologize, I can't tell you exactly if the judge said that was his basis for it. But it certainly was grounds for mistrial, and it was a state witness who knew this was an issue, and he knew whether the Judge Holcomb had ruled finally on it or not, that this was certainly something that was getting the defense's goat, whether it was admissible or not. This was something he was not supposed to talk about, having sat through the entire motion and limiting hearing. State just couldn't be bothered to instruct him because he's an experienced officer who sat through the hearing. And they even assured the court that on the other issue that caused the first mistrial before this one, that they had instructed their witnesses not to go there to say anything about gangs. But on this one, they just didn't bother. And I just think it's interesting and revealing that when there was a motion, one of the motions for mistrial and one of the motions to dismiss during the trial, the prosecutor quickly was able to paraphrase Oregon v. Kennedy, saying, I didn't, why would I want a mistrial? I'm not goading him. I'm not doing any of this. And he does the checklist on the Supreme Court's ruling. Because why would he want a mistrial, I guess? I guess it's okay if he's simply going to taint a jury so badly that the defendant has no choice. But that's, even though we don't have an admission, we've got all the evidence there that they just wanted to destroy this man's chances for a fair trial. Questions?
Thanks, Fred. Thank you, Ms. Newton.
May it please the court. I'd just like to briefly read when the trial judge granted the motion for mistrial. This is what he was thinking. They talked about the Eric Durant problem, and that's when it came up. Then they started talking about the motion in limine, confusing the issues. Again, the prosecutor never asked this guard, what did he say to you? He never intentionally violated that motion in limine. This was a spewing by the guard that was completely unanticipated. So they went through that. Then the trial judge says on page 58 of the May 11th hearing, that isn't what I'm ruling on. My ruling is as to the fact that it's obvious that the witness Durant would include in his belief not only what he observed at the time of the incident, but also as a result of this later bribe. So the trial judge was troubled by the fact that he really believed this witness was completely speculating. Incorrect ruling at the time certainly doesn't show a goading by the prosecutor. And going back to the real issue here, there was not a huge amount of improper conduct in this trial. This was a difficult trial. We had inmates changing their stories repeatedly. I don't think the prosecutor wanted to do this again, because who knows how many inmates are going to change their stories the next time. They thought that the readbacks that were requested were favorable to the state. They argued vehemently not to have a mistrial. They certainly didn't try to goad the defense into requesting one. And we would ask this court to reverse the trial court's order. Thank you.
Thank you very much.
Thank you.